The early review program involves staff members from the county attorney's office and the district attorney. The focus is on accused offenders brought to jail. Prosecutors now decide if charges will go to a magistrate judge, if another charge should be filed, or if the accused will be set free. The policy itself may soon be put on trial.
We've spoken with people at the Attorney General's office, and that's all I can say for now.
Ken Cassidy with the Austin Police Association did explain why the organization objects to what prosecutors are doing.
They've inserted their authority over the entire process and breaking the law as far as we're concerned.
Fox 7 obtained county jail documents that track the early review process from March to the end of June. It shows that 283 arrest complaints written by law enforcement officers were tossed out by prosecutors before being seen by a Travis County magistrate.
Is that tampering with evidence by intercepting and not letting a judge look at these cases?
We believe it is, and you know, the code of criminal procedure is very clear on how to handle an arrest and an affidavit, and they do not follow that.
The state code of criminal procedure states that it shall be the primary duty of all prosecuting attorneys, including any special prosecutors, not to convict, but to see that justice is done. It's a broad statement, but it gives prosecutors the authority to do an early review process. That, according to Rob Keppel with the Texas District and County Attorneys Association.
And I'm not even quibbling that whether there's probable cause. What I'm saying is the district attorney has the right to look at that and say, whether there's probable cause or not, I'm not going to file that particular charge. Maybe I'll file a different charge, but Mr. Police Officer, please understand, I am not pressing those charges. It has nothing to do with probable cause.
Monday, officials for District Attorney Jose Garza told Fox 7 that, to date, about 3% of cases have been rejected by the DA's office for not meeting the legal requirement for a felony charge. When there is not sufficient evidence for a case to move forward as a felony, the office either refers the case to the county attorney for misdemeanor prosecution or back to law enforcement for further investigation. By implementing early arrest review, the district attorney's office will no longer be letting through cases that law enforcement hasn't sufficiently investigated. In a Zoom meeting a week ago, County Attorney Delia Garza and the district attorney defended the review policy.
The only cases that are ripe for this early case review are non-violent cases, are cases that we determine do not pose a threat to public safety. I also want to just early on in this process, I know there's a lot of misinformation about our new policies that say we have not, that we have no rule in my office that we are not prosecuting any type of case. We are still prosecuting criminal trespass cases.
But Fox 7's review also shows that 105 criminal trespass cases were tossed out by the county attorney between March and June.
The process was interrupted, and that's a shame that those people on the receiving end of a criminal act did not receive justice.
Charlie Wilkinson with CLEAT believes it's all about pushing a political agenda.
If the Garzas would like to impact state law and change felony offenses, well, there's a building right here. The state capitol, get yourself elected, file a bill, and change state law. But this is not the way to do it, and you can't do it. Constitutionally, this is not your job.